Welcome to the Supreme Court of the United Kingdom, where today we're hearing the appeal in the case of the Queen on the application of Majera and the Secretary of State for the Home Department. The case is concerned with grant of bail by the first tier tribunal, and the question is whether the grant was void from the outset as a result of certain defects in the tribunal's order. I'm hearing the appeal with four colleagues, whom I will introduce now. First, Lord Sales.
Good morning.
Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
And Lady Rose.
Good morning.
The appellant is represented by several counsel, headed by Amanda Weston, Queen's Counsel, and I'll turn now to Ms. Weston and invite her to begin her submission.
My Lord, I'm grateful. My Lords, my Lady will be aware that this is Mr. Majera's appeal against an order of the Court of Appeal of the 11th of December 2018, upholding the Secretary of State's appeal against the Upper Tribunal's decision that concerned the status in law of an order made by the First Tier Tribunal to release the appellant, Mr. Majera, on bail, pursuant to the statutory provision then in force, paragraph 22(1)(a) to Schedule 2 of the Immigration Act 1971, which can be found at EF page number 504. I assume, in view of the court's introduction of the matter, that the court has received our response to the inquiry as to anonymity. For the avoidance of doubt, the appellant's position is that he did not seek, nor was he granted anonymity in the Upper Tribunal. And although the Court of Appeal followed its usual practice of anonymisation, he does not seek anonymity in this court. In the time available to me this morning, I propose, firstly, to make a preliminary point on the facts to establish what we say was the point of the Secretary of State's restriction notice, and the ways in which we say it sought to cut across the First Tier Tribunal's pre-existing bail order. In other words, we will seek to demonstrate that the Secretary of State issued a document, the restriction notice, which purported to replace the existing bail order and sought to impose further restrictions superseding those set by the First Tier Tribunal, those being, notably, first of all, a prohibition on voluntary work, which the Secretary of State had requested and the First Tier Tribunal had declined to impose. Secondly, weekly reporting at Beckett House, in addition to other reporting conditions contained in the bail order, and purporting also to veto a decision by the offender manager to reduce the appellant's curfew hours. And I'll come to the documents in which those restrictions are contained. The Secretary of State's suggestion in her written case that these changes were somehow immaterial, we say is quite clearly incorrect. The issue, we say, is whether the Secretary of State was entitled to issue that notice to the appellant in circumstances where she had not challenged the bail order nor made any application to the First Tier Tribunal to vary it. And then secondly, without repeating our detailed written submissions, I will then seek to draw out some of the reasons why we say the Court of Appeal fell into error and why the Secretary of State's case is at odds with the weight of authority seen in the context of Parliament's decision to enshrine in law the status of the First Tier Tribunal as part of the independent judiciary, whose independence is expressly vouchsafed by statute. Our central contention is that the First Tier Tribunal's bail order fell squarely within the normal rule that a party cannot act inconsistently with a court order unless or until it's set aside. That is the principle articulated by the House of Lords in the case of Isaacs and Robertson, and applied in the context of courts of limited jurisdiction in cases such as the DPP against T, which is at EF 738, and more recent statements of the principle have adopted the formulation of any court, and we're referring there in particular to Lord Dyson, Master of the Rolls, in the case of KW, which is at EF 943. If that principle applies, that, in our respectful submission, is determinative of the appeal. We address this broad submission under the first substantive heading within our written case at EF 135 to 145. Our submissions on this point will include an examination of the two main claims raised by the Secretary of State. The first is that the normal rule to which I refer does not apply to a court order which involved the making of a jurisdictional error. This I will call the jurisdictional exception issue. The second main claim of the Secretary of State is that the first-tier tribunal order in this case was itself vitiated by jurisdictional error. This was the main finding of the Court of Appeal. We address this point at heading 2 within our written case at EF 145 to 156, which I will call the construction issue. In essence, our submission is that the Secretary of State is wrong on both points, and in summary, as to the first point, the jurisdictional exception issue, we submit that the normal rule applies to any court order, including one which involves the making of a jurisdictional error. We submit that this is clear from the weight of the authorities. As to the second, we say the authorities in which the courts have departed from the rule do not turn as such on categorization of the error as jurisdictional or non-jurisdictional, although that distinction may be treated as relevant, but rather an examination of the consequences for the parties and the statutory context in which those consequences must be examined. And here we refer to the analysis contained in the extract of De Smith in the Court's authorities at EF 2248. Then we say, even if the Secretary of State is right that an exception for jurisdictional error exists as a matter of principle, we submit that the defect in the bail order issued by the FTT was not, in any event, jurisdictional. That is to say, it did not deprive the first-tier tribunal of entitlement to embark on the inquiry as to whether SM should be released on bail. This is the narrow and original sense of jurisdiction identified by Lord Reid in Anisminic, quoted by Lord Carnwath in Privacy International at paragraph 47, EF page number 1729 at H. And that formulation being the tribunal being entitled to enter on the inquiry in question was the formulation used by Lord Reid, or indeed as encapsulated by Lord Justice Singh in TN Vietnam at paragraph 86 EF 1816, the legal authority to decide a question. In this case, whether a person should be granted bail. In effect, we say that the correct construction of the applicable bail provisions, paragraph 22(1)(a), is that the errors made by the first-tier tribunal in drawing up the bail order did not deprive it of jurisdiction to grant the bail it had just decided upon. Neither did those errors deprive the first-tier tribunal of jurisdiction to impose or not to impose the conditions it did. Aside from the statutory language, one of the many points we advance in support of this submission concerns the fundamental interpretive principle that bail powers, which may impose potentially serious interferences with individual liberty, should be strictly and narrowly construed. The Secretary of State and the Court of Appeal's analysis, we say, did not take proper account of this principle in the interpretive exercise. Even if the first-tier tribunal's bail order is now to be regarded as a nullity, the appellant has two fallback submissions, which are alternatives to each other, and which are described as points 3 and 4 in our written case, and will be addressed by Mr. Vaughan, who appeared before this court as junior counsel in both TN Vietnam, at which consideration was given to many of these issues, and in B Algeria, also a case before the court, in this case at EF 652. And these two submissions in summary are that first, the bail order nevertheless retained legal validity in the period before the court declared it to be a nullity, having regard to all the circumstances of the case. And second, that the court should not in its discretion uphold the Court of Appeal's declaration that the bail order is void and a nullity in all the circumstances of the case, which include that the Secretary of State declined to apply to the first tier tribunal to regularise the order. However, it's fair to note that there is a common thread running through the appellant's submissions, which is that the validity of flawed orders of courts and their legal effects has been determined by the courts by reference to the statutory context, the seriousness of any non-compliance, and its consequences, including in some cases, breaches of natural justice. On the facts of this case, the failure by the first tier tribunal to name the immigration officer and a time and date for reporting to him in the primary condition on the bail notice had no serious consequences. That is because he was required to report to his offender manager on a time and date set out at his licence. For the court's reference, that licence and the requirement to attend at a particular time and date can be found in the bundle at EF 418. Failure to do so would have rendered him liable to recall to prison, as well as immigration detention, and thus he remained under state supervision. It is not suggested by the Secretary of State that the first tier judge was not entitled to reach the view that bail should be granted to the appellant in all the material circumstances, nor that the error in question was material to the exercise of that judicial discretion. To the extent that our submissions rely on principles fleshed out more fully in the written case of the intervener, we adopt those written submissions without repeating them and will defer to Mr. Hussain QC to address the court upon them. As far as the appellant is concerned, the issues raised in this appeal are somewhat academic. He remains in the United Kingdom, awaiting a decision on his outstanding application made on the 2nd of April 2015, and is currently subject to immigration bail under Schedule 10 of the Immigration Act 2016, which can be found at EF 970. And under the respondent's current policy, he is permitted to undertake volunteering, which is distinguished under that policy from regular unpaid work. He remains living in home office accommodation, currently in Leicester. His current licence conditions include monthly reporting to his offender manager, and he has complied with his licence without incident, and there is no parasitic damages claim arising. It's right to say that whatever the court orders in this appeal is unlikely to affect him directly. However, for the reasons set out in detail in our application for permission and expanded upon in the written submissions of the intervener, the appellant contends that the Court of Appeal's judgment contains errors of potentially wide significance, which it's necessary for this court to address. On the point of terminology...
Can I ask you a question? Are you going to be asking the court to grant some form of relief?
My lord, Mr. Vaughan is going to be dealing with the question of relief. We say that it's appropriate for this court to uphold or restore the decisions of the upper tribunal.
Thank you.
On a point of terminology, I should say that we refer to the document generated by the first tier tribunal when granting bail as the bail order, and that order can be found at EF 384. I shall shortly take the court to it. Because the notice of grant of bail is a notice of a decision by a court, which must be complied with by the detainer, and the first tier tribunal procedure rules make specific provision for that. The rule in question is Rule 43, which can be found at EF 633 of the bundle, and we deal with that, the relevance of that rule in our written case at paragraph 11, which can be found at EF 133. So I'd like to, if I may, briefly turn up some documents relating to the application for bail and the decisions that were made. The first document that I'd like to take the court to is the Secretary of State's bail summary at EF 382, where the conditions which were sought by the Secretary of State in the event of a grant of bail are set out, and that's at the bottom half of EF 382. So we can see there, my lords, my lady, that a specific condition is sought in respect of cooperation with conditions of electronic monitoring and variation of address. But importantly, at point 6, the Secretary of State asked the first tier tribunal judge to attach a condition at point 6 that the appellant must not enter employment, paid or unpaid, or engage in any business or profession. So that was a specific condition sought by the Secretary of State. The bail notice itself is at EF 384. And we can see there, and it's not disputed, the defect in the making of the order. We can see the primary condition of bail is there included as the applicant is to appear before his offender manager. We can see that the condition that the first tier tribunal judge attached as secondary conditions is at 385, i.e. bail is granted in the same terms as the licence, and we take that to be a shorthand that any breach of the licence would result in a breach of this bail order. And in particular, at the 4th point down, just by that tick, the penultimate tick on the page, must not enter paid employment or engage in any business or profession. And the first tier tribunal judge therefore did not impose a condition relating to unpaid or voluntary work. The notice, the restriction notice issued by the Secretary of State is at EF 416. That is a document we can see is dated the 30th of July 2015, and we see that from the top of page 417. The document is entitled Notice of Restriction. It states at the top of page 416, you are detained under paragraph 2 of Schedule 3 to the Immigration Act 1971. It then purports to set out a number of conditions. Key in those conditions is the prohibition on paid and unpaid employment, and in particular we can see that an additional reporting condition is imposed at point 1. That is to say, reporting to the immigration officer in Beckett House SE1. I'd like, if I may, to make brief reference to the document at 420, EF 420. That is a communication from the appellant's solicitor, Mr. Ferner, and in it he points out, first of all, it's clear from this document that the additional imposition of restrictions appears to have become known to the appellant solicitor on the 30th of September 2015, which is the date of the email. And what that document does is set out a complaint about the restriction notice having been issued at a time when there was a valid bail order already in place, and bail had been granted pursuant to that bail order. Sorry, bail had been granted and as reflected in the bail order. We can see at 421 the Secretary of State's response to that complaint. Now, I don't intend to go back over the various iterations of the Secretary of State's position on the status of the bail order, and those are set out in our written case. But for instant purposes, we would simply say that what these documents show is that on the day on which bail was granted, the Secretary of State issued a document by which she sought to supersede or replace the bail order and its terms. So if I could continue just by making some points which I hope are relatively uncontroversial. The first is that first-tier tribunal judges are members of the judiciary. They have jurisdiction to grant bail with or without sureties or refuse bail. And this is a decision with effect in law precluding a further application until an elapse of a specified period. So if a bail application is made and it's determined adversely to the applicant, there is then a delay by operation of the rules, which must elapse until a further application can be made. They can grant conditional bail, they can grant bail in principle, contingent on, sorry.
Yes, can I just ask, is there a right of appeal in relation to a bail decision to the upper tribunal?
My lord, no. There is no right of appeal. The options, if you're unhappy with the decision of the on bail by the first-tier tribunal, are either if in respect of a decision to grant bail subject to conditions with which, owing to a material change in circumstances or some other reason, you wish to change the conditions, the solution is an application to vary those conditions. But in respect of a complaint about the substance of the or the procedure by which the bail decision, the decision to refuse bail was made, or to grant it indeed, then the solution is an application for judicial review or normal judicial review principles to the upper tribunal.
And so is the right to go back to the FTT essentially unrestricted, but if you're trying to raise a point that they decided 2 days ago and there's no change of circumstances, they would just apply a rule saying, well, we're not going to look at it again as a matter of practice in the exercise of our...
Essentially, yes, that's not set out expressly in the rules, but the normal practice in my submission would be if you've got a complaint about the terms of the conditions, then you'd have to make out your case on why they should be varied by the judge at a particular time. And that might relate to a practical matter which has arisen, or it might relate to an error, as in this case. There is no reason in principle why the first-tier tribunal judge wouldn't be able to consider what to do. What they then decided to do would probably turn on whether the first-tier tribunal judge felt it appropriate to interfere with a decision made recently by a brother or sister judge.
And at some point, not now, it would be quite useful just to have a note of the relevant statutory provisions that give effect to what you've just been telling us.
Yes, that would be as set out in the procedure rules. my colleague, Mr. Vaughan, has indicated that that's something that he's able to do shortly.
All right, thank you.
Thank you, sir.
Ms. Weston, just before you continue, could I, just while we've stopped for questions, looking at the statute, as I understand it, one could be given bail by the Chief Immigration Officer. What do your submissions vary according to whether the bail was given by the Chief Immigration Officer or the First Tier Tribunal?
My Lord, it may be helpful if I explain what happens in practice. So an immigration detainee applies to the Chief Immigration Officer for bail. Bail is either granted on terms or refused. If it's refused, an application is made to the First Tier Tribunal. The document that I took the court to, which is the bail summary, where the Secretary of State sets out all the reasons why bail should not be granted, is before the tribunal judge. The tribunal considers that. It considers what the submissions are made by the individual seeking bail, and then effectively, and as this is set out in the bail guidance of Mr. Clements, which is in your authorities, and I can refer to it, undertakes a risk assessment. So the bail judge then assesses what the relative risks are against the principle that detention should only be used as a last resort, and then decides whether bail should be granted. That's to say, whether such risks as there are can be managed, and if so, what those conditions should be in order to do so. So effectively, the task of the judge, we say, is different, because the judge is adjudicating on a situation where the Secretary of State has refused to grant bail and may reject the Secretary of State's reasons for detention. And indeed, as Lord Lloyd-Jones has pointed out in B. Algeria, and the reference is escapes me, but I know that I have made a note of it. Yes, it's at EF 668, paragraph 41. EF 668 C to G. Lord Lloyd-Jones there is canvassing the point that although the First Tier Tribunal does not have jurisdiction to rule on the legality of the detention, nevertheless, the judge can make a decision on whether, in his view, it's unlawful, he or she, and he can so inform the Secretary of State. If, in the light of the First Tier Tribunal judge's conclusion on legality, the Secretary of State disagrees, well, then that can be a matter which is dealt with by way of an application to the administrative court. But it's certainly part of the inquiry, even though it's not technically part of the jurisdiction.
But that's not a factor in this case, is it?
My Lord, no. I only raise it to point out that what the First Tier Tribunal judge is doing is substantially different to what the Chief Immigration Officer is doing when looking at the question of bail.
So is your position then that effectively the FTP is acting as an appellate body almost from the decision of the Chief Immigration Officer, even though it's not set out like that in the provision? And also, if the FTT refuses bail, you say the Secretary of State can judicially review that decision to the administrative court? Is that how you say it works?
My lady, yes. I wouldn't describe it as an appeal as such, because this is the First Tier Tribunal judge looks at the question of risk entirely for him or herself. It's not a question of finding something wrong with the Secretary of State's reasoning or other error of law. It's purely the First Tier Tribunal judge looking at what the Secretary of State has said and the reasons why Secretary of State has refused to grant bail, looking at what the individual seeking release is saying and adjudicating on it, sometimes to the adversely to the Secretary of State and sometimes adversely to the detainee, but it's wholly a matter for the first-tier tribunal judge. And if and insofar as the Secretary of State doesn't like the response of the first-tier tribunal judge, she can only complain about it if she can make out errors falling within the rubric of judicial review. My Lord?
Just on the facts in this case, had M applied then to the Chief Immigration Officer for bail and was unhappy with the conclusion, or did he go straight to the FDT?
My instructing solicitor is sitting to my left. I'm wondering if I might just turn my head for a moment. My solicitor is saying that no application was made to the CIO in this case, simply because on experience where a person has a history of criminal convictions, as in this case, it's highly unlikely that the Chief Immigration Officer is going to grant bail in any event.
Yes, thank you.
I'm looking at the time and wondering, as I've agreed to carve up the time a little bit, I'm wondering if I might crack on with my planned submissions, subject of course to the court's further questions. I've given myself only another 30 minutes to deal with what I have to deal with in order to make sure that Mr. Vaughan and Mr. Hussain have an adequate practice.
Okay, can I perhaps perhaps help you to focus a bit, slightly? There are two aspects to the central issue. One is the presumption of validity of acts before they're quashed or set aside or reversed, or the other is what the consequences are in law of a decision being set aside. Now, on the first of those, you're focusing at the moment on the tribunal being a court. I'm wondering if that's actually critical at all, or if it's not a wider principle which would apply also to administrative decisions. But there are these two separate aspects I think you need to cover. The presumption of validity prior to being set aside, and then what the effects in law are of the decision being set aside.
My Lord, I'm grateful. We say, my Lord, that there is a key distinction between judicial decisions and administrative ones. We note that the legal authorities addressing that key distinction have been dealt with in much greater detail by the intervener in their written submissions, and we will be adopting the intervener's submissions on the detailed analysis in the authorities as between court orders and administrative decisions. On the nature of the error or the defect in the bail order in this case, we say that it was a key characteristic of the defect in question that the primary condition, which the first-tier tribunal did not include in its bail order, was not discretionary, did not form part of the inquiry as to whether bail should be granted. It was a statutory condition required to be imposed if bail was granted in order to secure attendance as required. We note that the Secretary of State does not dispute that. The executive nor anybody else can disregard or ignore a court order made by a court or tribunal. We see that at EF 164. Also, that the Secretary of State accepts that the normal rule that a court order must be complied with unless or until it's set aside doesn't necessarily depend on whether the court is of limited or unlimited jurisdiction. And we see that at EF 182. Just to finish my submission on the effect of the restriction notice, we say that what had happened on the facts was that the Secretary of State treated the bail order as something she could replace with that document. But we also address the point that the Secretary of State makes that the further restrictions were immaterial because the upper tribunal had held that there was a freestanding power which could be superimposed under paragraph 2.5 of Schedule 3 to the 1971 Act. Our response to that is that the upper tribunal's treatment of that issue was obiter and only relevant on the alternative basis that the order was no longer in force. And we see that from the upper tribunal's judgment at paragraph 62 to 64, which can be found at EF 270. Importantly, and this is also relevant to remedy, we say that the upper tribunal would not have quashed the Secretary of State's decision to impose the work restriction if it had been an operative part of the ruling. Forgive me, I'm just going forward to make sure that I deal straight away with the court's focused points. So our first proposition on those points is that the court order had to be obeyed until it was set aside or varied, and that there's no category of exception for jurisdictional error. We rely in particular on our written case at paragraphs 15 to 59, EF 135 to 145, and we also rely on the intervener's written submissions on this point at EF 194 to 207. The Secretary of State's position, we say, may be summarised as, firstly, looking at paragraph 7 to 17, EF 165 of the Secretary of State's written case, the Secretary of State states that she did not in fact disobey the order because the appellant was released subject to additional conditions that the Secretary of State was entitled to impose. And the appellant's answer is, for all the reasons I've given in the by relation to the actual documents in the case, this position is not tenable. The Secretary of State's central claim that there is a jurisdictional error exception to the principle in Isaacs is, in our submission, incorrect. On the authorities we cite in our written case, the jurisdictional status of an error is insufficient to justify an exception to the general rule that an order of the court should be obeyed. I will then go on to address if that exception exists in law, whether it applied in this case. Sorry.
Ms. Weston, can I just take you, in your authorities, in your case, page 157, the first authority you cite is Smith and East Ellen.
Sorry, my lord, I can't hear you.
The first authority you cite on page 157 is the decision of the House of Lords in Smith and East Ellen.
Yes.
And you quote what was said by Lord Radcliffe. Now, that wasn't dealing with a court decision. That was dealing with a compulsory purchase order.
That's right.
So I'm wondering whether why you frame your proposition, why you confine it to court orders specifically, when the authority you're relying on was concerned with an administrative act.
Yes. We have, the way we've structured our argument is to say, first of all, there is no a basis for identifying an exception based on jurisdictional error. And second of all, even if that jurisdictional exception existed, the intention of the Parliament was not that total invalidity should result from non-compliance with the provision. That's how we've dealt with the structure. It's right that there has been, and I think this comes out, there's a certain amount of elision between the way that the principle relating to the status of orders and administrative decisions has developed. That in my submission is answered by the following sort of global submission, we say, which is that whether you're examining the problem through the prism of the status of court orders, or whether you're examining the problem through the prism of what Parliament intended by way of statutory construction of where the total invalidity is intended, the approach by the courts amounts to the same thing, which is to look at the statutory framework which applied, to look at the actual impact of the error in the individual case, and look at the consequences for the parties. So the point we're making is that jurisdictional error per se, as a category, is not a basis on which the courts have held court orders to be invalid, even if they have what might be described as a jurisdictional defect. It's, my Lord Legate.
Presumably the Smith and East Gallo line of argument could be made about the Secretary of State's decision, the restriction order. So how does that fit in with the analysis in terms of the FTT decision? It's the court one that prevails when there's a conflict?
Yes, that's right. We say that it's the court order that prevails. Yeah. It's a very basic underlying principle, which is the separation of powers and the jurisdictional field of operation.
But I mean, you applied for judicial review of what the Secretary of State had done. So,
that's right.
So even if there was a presumption that what she'd done was valid,
yes,
you found a procedural mechanism to bring that before a court to challenge that.
That's right. I think it's also important to point out that the issue about the fixing the defect in the bail order was complex, because by the time we were arguing with the Secretary of State about whether the Secretary of State was entitled to issue that restriction notice or not, by the point that the Secretary of State was saying that the First Tier Tribunal no longer had any jurisdiction and they could make that order, and that the First Tier Tribunal's bail order and conditions was no longer operational at all, and the First Tier Tribunal was no longer seized of bail. That was the position of the Secretary of State by then, albeit on an erroneous basis, which was that the Secretary of State at that stage said that the reason for that was because by reporting to the offender manager, the bail had been brought to an end, and that was because of the principle identified in AR Pakistan about non-finite about finite orders of bail.
It sounds as though there are a number of ideas here which are at risk of being confused. As I understand it, you're not really relying on the Smith and Eastello point, which is that an official act or decision has to be complied with unless and until it's set aside.
We are saying that, my lord.
Well, it sounds as though you're relying on a point on a proposition which is specific to the court and reflects a separation of powers as well. I don't know if it does, but it's specific to the court that a court order must be obeyed unless and until a higher court sets it aside.
My lord, yes, we put it in the alternative. Our first point is that the status of the court order is that it must be obeyed unless or until it's set aside, and that the circumstances in which the courts have been willing to depart from that principle are very narrow indeed and turn largely on issues of consequences of breaches of natural justice, which is absent here. Because I see that Mr. Hussain is raising his hand.
My lord, I'm very sorry to interrupt. Ms. Weston referred to our case where we address precisely the difference in approach as between administrative action on the one hand and court orders on the other, and it's paragraphs 16 to 24 of our case, EF 204 to 207. I hope that's helpful.
Yes,
apologies.
And it sounds also as though at the stage when you're thinking about what the consequences of an order being set aside or varied, and again, there are general arguments in administrative law about that, which have something to do with discretion in relation to relief. But it sounds as though you're making a more specific point, that this particular defect, being one capable of being cured by a variation of the order, given its nature and given the fact that it could be cured by variation, ex hypothesi, you can't vary a nullity. So I think that's a basis on which you're saying that it can't render the defect isn't of a nature which could render an order a nullity in any event.
Exactly, for two reasons. One, the point that my lord just made, which was that the remedy was if the Secretary of State was unhappy with the terms of it, was to make an application for variation, not to ignore it. But secondly, the circumstances in which the courts have been willing to depart from the normal rule that the court order should be obeyed unless or until set aside have related to orders where the procedural irregularity has led to, for example, a serious breach of natural justice, and that's the McSee case that the Secretary of State relies on. However, in this case, there was no serious consequence of that order because the primary condition that the judge included was one that required him to report in accordance with his licence conditions, and his licence conditions said that he had to report at a certain date of time on the 31st of July to his offender manager. If he hadn't have done so, my Lord Legate.
I mean, your basic proposition's a terribly simple one, isn't it, Ms. Weston? Courts make orders every day of the week that unfortunately get reversed on appeal, not infrequently. And it's no good saying that you don't have to obey the order because I've won the appeal, so I never had to obey the order in the meantime. And you don't go into an argument at that stage on the appeal about whether the original court just made some ordinary error of law or some more far-reaching one that went to its jurisdiction. I mean, that doesn't come into it. You just have to obey the court order until the appeal court says something different. It's as simple as that, really.
Exactly so, my lord. That is our first argument. That's our first proposition, indeed. I had sought in my oral submissions to address a couple of points made by the Secretary of State, and I can do so briefly before I invite Mr. Vaughan to pick up. The first is that the cases identified by the Secretary of State as of being examples where the court has been willing to treat a court order as void ab initio, effectively applying a ruling as to its legality to have retrospective effect, are very, very different to this case, and they involve, as I've submitted, cases, marital cases relating to serious procedural failures, giving rise to serious breaches of natural justice. And one example of this is to look at the Dennis and Dennis case on which the Secretary of State relies, to see what the court's rationale was in that case for setting aside the order and declaring it to be void ab initio and not having had legal effect. If I could just turn up the case, it's at EF 715. So this is a case where the court was faced with a situation where the petitioner had not been served in accordance with the relevant act, which at the time was the Matrimonial Causes Act, and the court was looking at whether the decree was voidable or void. Now, I'm avoiding getting into a detailed discussion at this stage about the applicability of concepts of voidable or void in the modern law to public law issues such as an order for bail by the court in this case. But it's important in my respectful submission to have a look at why the judge considered that this case to be one in which a declaration of that kind should be made. And we see the rationale at 733 at A to C. We can see there that the judge set out the statutory scheme and that the statutory scheme under the Matrimonial Causes Act provided for a two-stage process, and it's designed to protect the status and the rights of both parties, and we see that at B. Divorce affects not only personal status and capacity to remarry, but inheritance and pension rights, thereby underlining the importance of making sure that the process of making the decree nisi was procedurally correct, and then sets out further rights applicable. It's clear there that the court is identifying a specific category of very serious prejudice to one party by reason of the procedural breach in that case. And then in any event, if we look at Wall J as he then was, says at E, he underlines the principle upon which we rely. Plainly, any person who is the subject of an order of the court which turns out to be made without jurisdiction must obey it until such time as the order is declared by the court to have been made without jurisdiction or is set aside. That is the principle on which we rely, as my Lord Justice Leggett has. And there is nothing in my respectful submission in this case of Dennis and Dennis, which is of a type with the sorts of cases that the Secretary of State is relying on, to carve out this exception to the principle summarised better than I did by Lord Justice Leggett. Sorry, my Lord Leggett.
I find it difficult to see how this decision is actually consistent with the principle. I mean, I can't see a reason to distinguish divorce cases unless there's something I don't know about them. But why wasn't the decision voidable rather than void? It should have been, shouldn't it?
What I have accepted is that in specific narrow circumstances, the courts have departed from the general rule, from the normal rule on which we rely. This is one such instance. It is confined to its own facts and circumstances, which do not apply in this case. And in any event, the thread of the reasoning is very much focused on serious consequences of injustice for one party. Now, I know that Mr. Hussain and his team in their researches have discovered a decision by Lord Justice Munby, which seeks, called M&P, which seeks to encapsulate the rationale of decisions which have carved out an exception to the general rule. That's a case on which he's going to be making submissions, so I don't take it further. My global submission is this: yes, the Secretary of State, we rely on the general rule, the normal rule. We say it applies in this case. The Secretary of State has identified some discrete circumstances in which the courts have departed from it, none of which we say are an answer to this case.
But the defects in Dennis and Dennis included not just the failure actually to serve the decree absolute on her,
Yes,
on the wife, but was it also the prematurity of the application by the husband and the failure to serve a notice of application? So it may be
that's
that
right.
this case is a bit closer to they didn't have jurisdiction to embark on the inquiry, as you put it, than our case. You would say our case is that?
That's right. That is right. That factual set of circumstances is right. It's not clear with respect from the judgment that was the rationale of the court, which was very much focused on, one, what the statute expressly required and what the consequences were of failure to comply with the statute's requirements.
Do we need to worry very much about a single High Court judgment in family law?
My lord, there's a few of them. I'm only going to one of them, but they're going both ways, helpfully. So some judges have gone, but hence the reason why I'm deferring to Mr. Hussein's skill to explain why, by reference to not to make him a hostage to fortune, according to Munby's judgment.
If I've understood what you've just taken us to, it rather looks as though Mr. Justice Wall was affirming the principle that a judgment of the court stands and must be appealed unless not until set aside or whatever. But he was saying the particular defect in that case was such as to invalidate, once it was being set aside,
yes,
the nature of the defect was such as to invalidate the decree altogether.
Yes.
And you say this case is different because it's a matter that can be put right by a variation.
Yes. And because of the consequences of the error weren't such as to drive a cart and horses through the statutory intention.
Yeah. But I mean, in our case, the original order of the FTT hasn't been set aside at all.
No.
So on your primary argument, as I understand it, we don't even get into what happens when a court does set aside an order, and does it treat what had happened before as void or voidable? Because in our situation, we didn't get to that point. Judge Narayan's decision was never set aside.
That's right. That's
okay.
right.
I just wanted to be sure I understood. We seem to be drifting off into talking about the consequences of the order, but the order's never been set aside.
No, that's right. And yes, and I apologise to the extent we've taken our eye off the target, because of course the Secretary of State never challenged that order. We challenged the restriction notice, and that's the remedy which we obtained.
So can I just be clear about that? Because your submission seemed to involve that this was carving out an exception, whereas it's not clear to me that it is carving out an exception to the basic rule. Is that where we're now at?
Yeah, yes. Well, the Secretary of State, I'm responding to the Secretary of State's case, which is that the exception to the general rule is jurisdictional error. And I'm saying it's not, and B, even if it were, it doesn't apply in this case. My Lord,
Sorry.
Lord Legate.
I understand the significance of voidable and void to be that if an order is voidable, then you have to obey it unless and until it's set aside. If it's set aside, it is as though perhaps it's never been made, but nevertheless, until then, unless and until it's valid. Whereas if it were void, you would never have to obey it in the first place, because it wouldn't have to be set aside in order to achieve that. And I just have a problem with the reasoning in this case you've shown us, is because it says anyway it would have made no difference if he'd held that the decree absolute was voidable rather than void, but he's going to say it was void, and that seems to me to cause problems. It meant it didn't have any effect regardless of his decision.
Well, yes, and I noticed that Mr. Singh has got his hand raised, and in fairness to him, it may be that he wants to correct a misapprehension. I don't know if you should do that now or when it's his turn to speak.
Mr. Singh, is there something that you need to say at the moment?
My Lord, it's just to correct how my learned friend is characterising the Secretary of State's case. We do not say there's an exception when it comes to the need to comply with court orders for where there is a jurisdictional error. We say all court orders have to be complied with, regardless of whether there's a jurisdictional error or not. What we say is that if there's a jurisdictional error, that's relevant to whether the order can be treated as void ab initio rather than voidable. I just wanted to clarify that, my Lord, in case it saves my learned friend some time.
Thank you. Lord Sales.
My Lord, Lord Sales.
Yes, it was really to follow on from what Lord Legate was saying. As I understand the voidable distinction, it has two potential points of relevance, and they're not necessarily the same. So you could talk about void and voidable and say, well, if it's void, it just never has any effect at all and people could ignore it. But particularly in light of what Mr. Singh has said just now, I don't think that is being said in relation to a court order here. The second sense is in which the terminology is used is looking at what the legal consequences may be if an order is set aside, looking at the interim period where it was in place and therefore presumptively valid, and people acted in relation to it, and things happened on the basis of it. And there the terminology, on my understanding, it goes to, if it's treated as void, does that have a particular set of effects in that interim period? If it's treated as voidable, does that have a different set of effects in that period? Now, it may be that that terminology itself isn't wholly helpful about addressing what happens in that interim period, but I just thought that I'd better put that on the table, if you like, so that the debate doesn't go off looking at a distinct question as to whether the order can just be ignored or not.
My lady?
Yes, just on page 217, of the bundle, the Court of Appeal's order did, at paragraph 3, declare the purported grant of bail void and a nullity. So they did purport to set it aside. And my understanding is that then, as Lord Sales says, the question is, now that it has been set aside, does that somehow retrospectively validate the notice of restriction that was given on the 30th of July, even if before that moment the notice of restriction was invalid? Can it somehow resurrect the notice of restriction because in fact those powers we now know did exist even though they couldn't have been exercised at the time? Because I think the Court of Appeal in their judgment say something about, well, this is academic because now we are setting it aside.
Yes, but my lady is right, and Lord Leggett and Lord Sales also, that the dispute between us is what the status of the order is up until the point at which it's been set aside.
Did the Court of Appeal have any jurisdiction to set
Yeah.
it? They weren't seized with the bail order at all.
Yeah, I wanted to make the same point. There was no judicial review challenge to the original FDT's decision. It just wasn't an issue.
No. Then we get into the territory of whether the Secretary of State is entitled to raise legality in the context of a defence to a judicial review, and what the consequences of raising that would be, indeed.
But I'm now a little bit lost. Why aren't you just saying that the Court of Appeal had no business to be making the order at paragraph 3 because there was no extant procedure which called in question the validity of the original order made by Judge Narayan?
Yes, we have identified that point as being dealt with under the heading of remedy, and it's Mr. Vaughan who's going to be dealing with that now. If I can hand over to him, my lord is right. We say that the failure by the Secretary of State, that the question of relief is very much determined by what applications were made when to challenge the decision. And in this jurisdiction, we have a 3-month time limit for challenging the legal validity by way of judicial review, and that wasn't observed by the Secretary of State. So, who didn't challenge it. So yes, that's right.
And Ms. Weston, one of the things that we learned in the Shamima Begum case was the importance of being clear as to what jurisdiction is being exercised.
Yes.
Was the Court of Appeal exercising, was it hearing a statutory appeal?
No, the Court of Appeal was hearing the Secretary of State's appeal against a judgment of the upper tribunal by way of judicial review. I
see. And is an appeal from the upper tribunal on an issue of judicial review, is that a common law appeal? No, it's not an appeal, my lord. It was an application for. So what happened was the Secretary of State issued the decisions. We challenged by way of judicial review to the upper tribunal the Secretary of State's decisions relating to restrictions. Yes.
The upper tribunal ruled in the judicial review in our favour.
Yes.
And the Secretary of State appealed that judicial review judgment of the upper tribunal to the Court of Appeal.
Under what? Is that under some statutory provision that appeal is brought?
It's firstly under the Tribunal Courts and Enforcement Act 2007, appeal from the upper tribunal, and governed by CPR 52 and Practice Direction 52C.
But I mean, so far as the upper tribunal is concerned, it's exercising the judicial review jurisdiction, which ordinarily resides in the High Court, but pursuant to various carve-outs, in certain cases, has been given to the upper tribunal.
That's correct.
So the upper tribunal judgment in our case could have been a decision of the High Court. But as it seems to me at the moment, the important point is that it was being asked judicially to review the Secretary of State's restriction notice, which was said to be unlawful.
That's
because
right.
The Secretary of State had ignored the Judge Narayan's decision in the first tier tribunal. correct me if I'm wrong,
Yes.
my understanding is that the Secretary of State has never challenged in proper proceedings by judicial review, as would have been, or yeah, well, it would have been judicial review or going back to the first tier tribunal,
That's
Judge
right.
Narayan, to vary it, the order made by Judge Narayan. So that is an unchallenged judicial decision.
That's right.
You have relied on that as the foundation for your judicial review of the restriction notice.
That's right.
And at first instance, you won. And then the Court of Appeal allowed the Secretary of State's appeal.
That's
But
right.
that's all focusing on the lawfulness of the restriction notice, not the original lawfulness of Judge Narayan's order.
That's right, my lord. Mr. Vaughan has prepared oral submissions precisely on this issue, and I'm wondering if now might not be a convenient time for me to cede my chair to him.
My lords, my lady, I address you on the basis that the specific rule in Isaacs and Robertson does not apply, contrary to our primary case. If that rule does apply, then in our submission, that is determinative of this appeal. But if we're wrong about that, we submit in the alternative that the bail order should nevertheless be treated as valid on the following bases. First, that the bail order should retain legal validity in the period before the court declared it to be a nullity on standard administrative law principles, having regard to all the circumstances of the case. And on this basis, my lord, yes.
I'm so sorry to interrupt. I am getting a little bit confused with the way you've just introduced what you're going to say. Why do you say that you're addressing this on the basis that the primary submission that the rule in Isaacs applies is wrong? I thought from what Miss Weston just said that you were going to explain to us that the Court of Appeal was wrong procedurally to be ruling upon the legality of Judge Narayan's order, because there was no procedure that had been started to challenge Judge Narayan's order.
Well, my lord, that is our case. That is our case. And
I'm so sorry to interrupt. If that is right, why, if the argument about Isaac is right and that there's no carve out or anything like that, why aren't you saying that what you're saying directly supports your submission based on there being no exception to the Isaacs rule?
Well, my lord, the answer to my lord's question is simply that the Court of Appeal had no jurisdiction to rule upon the bail order. The jurisdiction for the Court of Appeal's exercise of its powers was Section 13 of the 2007 Act. And so it follows, my lord, it's not in
Do we have that in the bundle?
I don't think it is in the bundle, but we can provide it. But the point is that, my lord, yes, the point is that that was the basis on which the Court of Appeal was there. And so it follows from that the Court of Appeal had no power to pronounce it. And in my submission, it's no more complicated than that. But our principal case is that Isaacs and Robertson is the end of the argument. Now, as I say, if we're wrong about that, we say administrative law principles are the answer, given all the circumstances of the case. And on that basis, the FTT bail order precluded the Secretary of State's additional restrictions that she imposed at the time. And this is the point that we make in our written case at 156 to 161. The second alternative is that in any event, the court could not in its discretion uphold the Court of Appeal's declaration that the bail order is a nullity in all the circumstances. And those circumstances included that the Secretary of State declined to apply to the court, the FTT, to regularise the order, despite being invited to do so by the upper tribunal. Now, I don't know whether this is a convenient point to flag up the procedural rules according to which the Secretary of State could have made those applications, which my Lord Sales asked for earlier. It's Rule 38 of the 2014 Tribunal Procedure Rules, and that's at EF 627. And that shows that anybody can apply to vary bail conditions, including the Secretary of State. There is also the slip rule at Rule 31 at 619, and this is the rule that we say the Secretary of State should have taken advantage of at any point. Indeed, the upper tribunal had invited the Secretary of State to do so after granting permission. The permission order is at EF 435. And indeed, by virtue of the overriding objective, those applications could have been made. So whether on the first or the second of those points in our submission, the just outcome in this case is that defects in the bail order should be remedied if they need to be by the Secretary of State making that application. So if Isaacs doesn't apply, the Secretary of State still ought to have applied to vary or set it aside before she acted inconsistently with it by virtue of the principle in Smith and East Ello. And of course, to use Lord Radcliffe's words in that case, the bail order bore no brand of invalidity upon its forehead. I'll not take the court to Smith and East Ello, but the reference is EF 2097 at 2130, final paragraph. So even applying general administrative law principles, a bail order was still presumed to be valid at the time the restrictions were imposed. But given that the Secretary of State did not apply to vary the order before acting inconsistently with it, should the Secretary of State's approach of, we submit, ignoring the tribunal's order in the hope that she would later show it to be a nullity, be approved by this court as the Secretary of State contends, or should the court take a more nuanced approach? And in our submission, we submit that this is precisely the type of case in which an absolute approach to nullity and retrospective invalidity would be inappropriate. In our submission, if we need to make it, a relative approach to nullity and retrospective invalidity is perfectly within the realms of public law, contrary to the Secretary of State's submission. Now, I'm mindful of the time, so I'm just going to give the reference to De Smith in Authority 69 EF 2246, in which De Smith identifies the problem. Sorry, Lord Legate.
Seems to me you're arguing in the wrong direction. The starting point for you is that the tribunal order was never set aside. It remained at all times valid. The question then is, what is the status of the Home Office decision?
Well, my Lord,
should be saying that never had any, should be treated as never having had any effect. And the arguments about how things can have legal consequences and discretion still regarded as having effect aren't going to help the respondent.
My Lord, I think the answer to that is the answer given by my Lord Sales, which is that the upper tribunal was not seized of a judicial review application of the notice of restriction. It was seized only of an application for judicial review by the appellant of the notice of restriction. Sorry, the bail order was never...
I'm not talking about the bail order, I'm talking about the notice of restriction. I thought it was seized with that.
Sorry. I beg your pardon. It was seized of the claim against the notice of restriction. But
therefore it's important, isn't it, to your case, to show that the notice of restriction is to be treated as never having had any effect and can't be rescued by some sort of argument that at least it had some consequences.
Well, my Lord,
some consequences.
My Lord, yes. I think the answer to that is that the bail order comes first. There are important constitutional reasons why that is the case, and those are set out both by the intervener in the paragraph references which Mr. Hussain gave the court, and in the appellant's case. And so it's not correct in terms of constitutional law to say that the bail order could somehow be disregarded. It couldn't, because of the separation of powers and because of the rule of law. Given the time, I will just flag. So the purpose of going to De Smith was in order to show that there are a number of ways in which the courts can prevent what has been described as the domino effect of recognising a measure to be retrospectively invalid. And reference is made at 2248 to a number of criteria, such as the exercise of official authority, such as judicial decisions, at 4072 to the context of the invalidity, to remedial discretion, and to restitution, which doesn't arise here. And those are some of the factors the courts have applied in deciding whether a retrospective approach to nullity is appropriate. And so, in terms of judicial authority, I accept everything my learned friend Ms. Weston says about the FGT as a judicial body. I'll give references to our case at EF 135 to 136. And on context, I haven't got time to flag it up, but the court will note from TN Vietnam that Lord Justice Singh approved the relative approach to nullity at EF 1815. And the significance of that concept in his reasoning was that it underlined the importance of a context-sensitive analysis of the problem in hand in order to determine, in that case, whether applying an ultra vires regulation gave rise to unlawfulness in every case, or whether some other test or consequence applied. And the court looked at the statutory scheme, the common law approach to procedural fairness, the law on systemic unfairness, finality, and of course, the underpinning contextual factor in that case was the fact that it concerned asylum determination. But the basic point is that those are the criteria. If one looks at those criteria in the context of this case, in my submission, it's clear that an approach which treats nullity as a entirely retrospective concept is inappropriate and would cause injustice. And we rely upon all the contextual factors that we have raised in our case in relation to the FTT's bail jurisdiction at EF 137 and to the consequences in terms of legal certainty. But I'm aware of the time, but I will just close simply by saying that there was a clear basis to treat the bail order as having legal effects which bound the parties, which precluded the imposition of the restrictions imposed by the Secretary of State. So on that basis, the Court of Appeal's declaration that the bail order was void and a nullity negated those legal effects and should be set aside. Unless there's anything further, those are my submissions at this stage.
Lady Rose has a question.
Yes, can I just be clear? The context points that you've just been making seem to me to be statutory construction points. Was Parliament's intention that these defects should give rise to retrospective nullity or not? And it seems to me that that construction exercise has to be conducted independently of the facts of any particular case. Because I don't see that the nullity or not can depend on the individual consequences for this appellant. But a lot of the other arguments you've put forward seem to be very case specific, and I don't see that those can actually affect the statutory interpretation as to what Parliament intended.
My lady, they are factors to put into the mix, and part of our primary case does make those statutory construction arguments. But the submission we make in the alternative is that they retain relevance when weighing up the approach that is required. And my reference to TN Vietnam shows Lord Justice Singh looking at the statutory scheme as one of the factors in determining whether a retrospective invalidity approach was appropriate. Unless there is anything further, those I will hand over to Mr. Hussain.
Yes, thank you, Mr. Ward. Mr. Hussain.
My lords, my lady, BID is most grateful for your lordship's ladyship having granted permission to intervene. My lords, my lady, do you have a 4.5-page note from me entitled Core Submissions?
No.
was received at, I think, 11. The reason I prepared it is to expedite my submissions, but seems to be having the opposite effect.
You should have done it for the last occasion, Mr. Hussain.
Yes.
You have to allow more time than 11 a.m. on the day.
I'm sorry.
In fact, it does seem to be in my SharePoint folder.
Yes, opening up my inbox just now, I now have it.
This will save me reading out references, if you don't mind. So these are our core submissions. May I please invite you to our case? But we say this appeal fundamentally concerns, as Lord Legate said, the duty on a party, a fortiori the executive, to obey, more specifically, not to disobey an order of a court. The rule derives from Creamer, paragraph 1 of our notes, Lord Cottenham, Lord Chancellor. He said, and it's good law, he said in 1846 that a party who knows of an order, whether null or void, regular or irregular, cannot be permitted to disobey it. It would be most dangerous if parties could themselves judge the question. They should come to court so that it might be discharged. As long as it existed, it must not be disobeyed. This, the Secretary of State has never done. They have never complied with the Creamer rule, never sought to discharge the FTT. The points that my Lord's made, my Lord Sales is making, we absolutely concur with. A number of points. You need knowledge, actual or constructive. The divorce cases, I'm going to come on to them. They are accommodatable in this rule. The wife in those cases, it was always the wife, didn't know that a decree absolute had been issued. And when she did find out, she moved the court. She complied with the Queen. The rule applies to null or irregular orders, void or avoidable, contrary to what the Secretary of State seeks to argue. The rule indicates what you're supposed to do, come to court, but it dictates action while the order is extant. It forbids disobedience while it exists. The Secretary of State says about Creamer, would you believe, with greatest respect, it's of limited assistance because it predates the distinction that the courts have now made between orders within and without jurisdiction. That rather ignores the fact, the wording of the rule, it ignores the fact that the distinction was basic to the argument. The plaintiff was arguing that the order of the court, which had been drawn up not on the basis of his consent, was a nullity, so he didn't have to come to the court, Pace Lord Legate. The defendant was arguing that it was irregular. And the court had the distinction, well, it might, it's obvious from the passages I've just read out. And it's not the case that the distinction has now been made. It's been eroded since Anna's Minute and the modern approach to judicial review, which we would say applies a fortiori in the context of court orders. We give you references in our case why it remains good law. Atkinson in 1952, this is a contempt case, if anything, strengthens the duty because Lord Justice Romas says it's unqualified and uncompromising because he emphasizes it extends even to cases where the person affected by the order believes it to be irregular or even void. That's emphatic. The strengthening I needn't bother you with in any detail. It's just in Creamer, there's a passage which suggests there might be a carve out if there's fraud. Did the defendant mislead? That's not there in Atkinson. And Atkinson then cites Creamer, and then Lord Diplock in Isaacs cites both. and approves how. Paragraph 2, the rule applies to all courts. That's very clear. There's only one case that, as far as we are concerned, has ever doubted that positively. And that's the Beck case, which we refer to at the end. Lord Justice Singh has said that's probably suggested it's probably wrongly decided. But Lord Justice Mance heard very little argument, he said himself, in that case. It's not a point that the Secretary of State's taking here. It applies where the court orders were in excessive jurisdiction in the pre-anismic sense, and in no jurisdiction to an entertained sense. And we've given you references there. It applies to see where the error is obvious. In Creamer, the consent, as I said, didn't reflect the basis of the consent order. In Lunn, what happens there, Lunn is EF 1642, Lord Justice Moore Big. What happens there is the judge sentences on a consecutive basis, and the warrant of imprisonment orders imprisonment on a concurrent basis. So, but it's given effect. Obvious error. And it applies to orders while they're in existence, even when it's later recognized that the order was unlawful. So disobedience isn't excused historically. And that's very important given what the Secretary of State is seeking to claim. And again, we've given you examples. I can come back to them if they're of interest. Paragraph 3, we say is important because we say this is the nub of it. It only has purchase when the order is unlawful, because otherwise there would be no extraneous, there would be another reason, a merits-based reason to obey it, deriving from the true legal position. The nub is what next comes in my paragraph, I'd respectfully submit. It concerns authority. It concerns authority. And the reason why the analysis, Lord Burroughs, for the Chief Immigration Officer granting bail on the one hand, and the court granting bail on the other, tribunal accepted to be a court, is that the executive is not an authority on the law. And the constitutional principles in play are completely different. It's the hallmark, absolutely the key concept of an authoritative body. I don't want to get into legal philosophy here. It is that its directives themselves constitute sufficient reasons. Yes, my lord.
I mean, surely if the chief immigration officer grants bail, the prison governor has to obey that and let the prisoner out on bail.
Yes.
And if anyone in that situation wanted to challenge that, they would have to seek judicial review of the chief immigration officer's order, wouldn't they?
Yes, but the interesting thing is that what would happen if it was quashed? The ordinary rule is retrospective invalidity. Let's say for whatever reason the individual wasn't released. It's a perverse order. You get JR. The ordinary rule, I take all of Mr. Vaughan's points, all of Ms. Weston's points. I absolutely agree with them. Discretion and so forth and the remedy. But the ordinary rule is nullity void ab initio. That is not the position with court orders. It's completely different.
Right, but it's not the position with the chief immigration officer either, is it?
It is. It's an administrative act. Of course it is. Everything else being equal. In this context, I completely accept it wouldn't be, but that is for a different reason. It's for a different set of reasons. It's to do.
Mr. Hussain, I'm sorry to interrupt. Are you saying that the prison governor could ignore the chief immigration officer's grant of bail if he thought that it was made outside the chief immigration officer's jurisdiction?
No, I'm not saying that, because there's other cases which show that the prison governor is obliged to obey an order of a court, even if he thinks it's unlawful. And I would say, in this context of liberty, he would be obliged to obey the Chief Immigration Officer's bail. The interesting question is, what if, because of inadvertence, he doesn't, and then somebody quashes the bail grant? What happens then? And the ordinary rule is that it's retrospectively invalid. That is not the rule with court orders. The analysis is different. The result, I accept, would be the same. I think that's the difficulty, maybe, my lord, you're having with my answer, because you may think the result is different. It's not. It's the same. I accept that. The route is completely different. It's completely different.
Mr. Hussain, may I just ask, if the test of when you can go behind the order is essentially the same for the first tier tribunal, because you have to get judicial review to go behind it, and for the Chief Immigration Officer, because you have to get judicial review to go behind his order, why wouldn't the approach to the consequences, if you've obtained an order in either of those cases, quashing the order, be essentially similar? That it would be a matter of statutory interpretation as to what Parliament intended the consequences to be in that situation.
I'm going to answer. I'm really sorry. I've got to carry on. I've got a lot to do. It would be the same. The statutory construction points would bite on the JR of the Chief Immigration Officer's bail. It would go to remedy. Do you give the quashing of the, if it is quashed, the quashing of the bail retroactive effect? Assume it was that the individual is not released. So that would be the route. That's not a consideration when it's a court order. You just got to obey it. And that's really important, because the Secretary of State is precisely trying to analogize the position between the executive and the courts. She is completely wrong to do so. The constitutional imperatives are completely different. And I'm trying. I'll develop it in a minute. The Mossel case, Privy Council, Lord Phillips, the telecommunications case, explains that very clearly, giving you a reference at paragraph 5 of our note. But if I can carry on. So you've got the point at 3. This is about the authority of the court. The nature of authority is it excludes other reasons as sufficient reasons for acting. Paragraph 4, the suggestion made by the Secretary of State is that she has a duty to obey a court order, but once it's recognized as unlawful, or we would say quashed, and there wasn't a quashing order sought here, it was just the court took it upon itself to declare it unlawful in this case. This paragraph 74 of the Court of Appeal judgment.
And what do you say about? Do you have anything to say about that?
It's an arrogation of jurisdiction that was inappropriate.
Yes, procedurally, the Secretary of State raised the invalidity of the bail order in her defence.
Yes.
In his defence, I'm not sure, to the
yes.
And the Court of Appeal then treated it in its very first sentence. It's the issue in the appeal.
Yes.
And procedurally, is that what would you say about that?
Well, it's not just a procedural problem, it's a substantive problem. It's a substantive problem with the Creamer rule. The court in Creamer says your remedy, if you're unhappy with a court order, is not to ignore it and take your chance and then raise it by way of a defense to the judicial review of a subsequent decision that you have made. Your remedy is to move the court. In the divorce cases, that is what the wife does. She moves the court. She doesn't say, oh, well, the decree absolute was invalid, ab initio, was void, in later proceedings for financial assistance or something. She moves the court immediately. The divorce cases are an application of the rule in Creamer. This was a violation of it. The Court of Appeal were completely wrong, we respectfully submit, with great respect, at paragraph 74, to say an order has been sought. It hadn't been sought to quash the bail. It absolutely had not been. This is 74, 237, they say, and this is Lord Justice Haddon Kay with respect to him, an order has been sought declaring the first tier tribunal's grant of bail a nullity. It had not been. That's just wrong. And it's more than a procedural issue we respectfully submit. It's a substantive failure to abide by the rule in Creamer. But going to what is perhaps the heart of the debate between us and the Secretary of State on this point is the Secretary of State claims a power effectively to be retroactively forgiven for her historic disobedience if it later transpires that the court order was unlawful. Query how it's unlawful. I'll come on to excessive jurisdiction, obviously wrong, error on its face in a minute. But that's the claim. We say that empties the rule of its important content because it encourages second guessing, it permits the ignoring of the order rather than compliance with the rule in Creamer, bringing it back. It undermines the authority of the court and the administration of justice, and indeed the rule of law. It replaces what Hodkinson described, Lord Justice Romer, as an unqualified, uncompromising duty to obey with a contingent duty. The Secretary of State effectively is saying to you, my lords, my lady, I will obey the court order unless I myself think that it's irregular on its face, obviously erroneous, or an excessive jurisdiction. And if that's the case, I'll take a chance. I won't move the court. I'll take a chance, raise these points by way of defense. And if my argument is accepted, my historic disobedience will be forgiven. And we say that is contrary to both principle and precedent. It's most dangerous. It's also difficult to apply because of the category problem. We'll come on to that. And point 5 is the point that formed the basis of the exchange between certain of my lords, Lord Reed, Lord Sales, and Miss Weston. And we don't start with Smith and East Allo or Hoffman La Roche. We start with the rule in Creamer. As Lord Leggett said, that is the point here. The Secretary of State seeks effectively to relegate court orders, and it is a relegation to administrative acts or subordinate legislation. And that is what the Court of Appeal held, the reference is given. And the reference I interrupted to give you, I hope it was helpful, is there, 16 to 14 of our case, pages 204 to 207. The critical point is that administrative acts, subordinate legislation, that they are presumptively valid unless and until set aside. There's no rule saying you've got to obey them. They're presumptively valid, but once in general terms, a court quashes them, they are null. And the greatest example of that, perhaps, is Miller 2. So the advice to the Queen, the order in council, the prorogation itself, blank piece of paper.
Surely the landowner in East Ello had to abide by and obey the compulsory purchase.
Yes, but once, if he won, then that order, well, everything else being equal, in that situation, it probably wouldn't have been. There would be lots of second actors, lots of unraveling problems. But the principled position would be that it was retroactively invalid. Can I just take you to...
Sorry, I'm sorry to press you on this. In East Ello, the landowner very specifically sought to disregard the compulsory purchase order. They said it was made without jurisdiction, it's void under nullity, I can ignore it. And the House of Lords says, no, you can't.
Pro tem, you couldn't. The issue is, it's the temporal issue. Can I just, I think I really do need to take you to, if there's one case I want to take you to show the contrast, can I take you to Lord Phillips in the Privy Council? This is a telecommunications case of Mosul. It's 37. I'm very concerned about the time. It's tab 37, but it's important I address this because the analysis in our submission is totally different. And you get that from Lord Phillips for the board. And so this was a case where the minister issued a direction concerning telecommunications regulation to the body that was responsible. And the issue was, could the body ignore the order of the minister because it received legal advice that it was unlawful? And guess what the Privy Council said? Yes, it could. That's the point. If we then go, my lord, to, I'm sorry if I'm going too quickly, but I want to take you straight to 1371, where paragraph 40, Lord Phillips says that the lower court was correct to hold that the minister's direction was ultra vires. And if you look at the facts, it's not surprising. If you look at paragraph 37, it's clear why it was. But the interesting thing is, once they declare it was ultra vires, what are the consequences retroactively? And then you see at paragraph 42, and this is the point, Lord Sells, you were making to me a moment ago. It was Digicel's submission that the OUR, that's the body, not the minister, that's the body, was bound to comply with the direction unless and until it was declared invalid and quashed. Smith and East Allow, Lord Radcliffe, and then, importantly, it was held impossible in that case for the appellants to take the necessary proceedings to get the order quashed. Relevant legislation required any challenge to within 6 weeks. They were out of time. So, sorry, that's the correct answer. I'm sorry, I gave you a poor one. That's the correct answer. You couldn't get before a court. Therefore, yeah, you had to comply with the Administrative Act, the compulsory purchase order. Then Hoffman-La Roche, the famous passage. Here too, important to recognise the context. The Crown was applying for an interim injunction and so forth. This was a price, there was a price fixing case from memory. And then 43, both these cases and much of the rest of the extensive jurisprudence on the vexed question of the effect of executive orders and administrative decisions before a final judgment is reached on ability were considered by the House of Lords is in Boddington, and then that is cited, Lord Irvine. He adopted from memory the extreme view. Lord Brown Wilkinson talked about second actors, as did everybody else. And then the board would reject entirely, strong words, Digicel's submission that the principle established in Boddington is relevant only in the context of a criminal prosecution, and not, as here, ministerial directions. The board would reject too the suggested analogy between directions and orders of superior courts. I accept superior courts, but we've seen the wealth of authority which says the rule applies to all courts, which it is well established, see Isaacs, must always be obeyed. Isaacs did concern a high court, court of unlimited jurisdiction. Whatever their defects, until set aside. That's the difference in the rule. They reject the analogy. What it comes to is this: subordinate legislation, executive orders, presumed to be lawful if and when they're successfully challenged and found ultra vires. Generally speaking, the point I was trying to make, the general rule, is as if they never had any legal effect at all. The nullification is ordinarily retroactive, rather than merely prospective. There may be occasions where declarations of invalidity are made prospectively or are made for the benefit of some, not others. And then second actors, per se and Hall.
Mr.
Over the page, sorry, my lord.
This seems to be affirming the point at the first stage of the 2 points that my Lord Reid identified quite early on in this hearing, that we need to distinguish. What is the approach to be adopted to a court order or an administrative act which has not yet been challenged and ruled upon to be unlawful? And this case seems to affirm that at that first stage, the administrative act is treated as lawful.
Oh, absolutely.
What it then goes on to discuss is, but if you have an order setting aside the act as unlawful, as there was in this case, what are the consequences of that for the interim period, which, as it seems to me, is a completely different question from the first question.
Yes.
I mean, I know that the argument seems to wander off into the second question, but it's, as it seems to be at the moment, the primary point on the first question seems a very strong point, and I'm a little bit unclear why you're not emphasising that at least as well.
Because of the second question, because in this case, the Court of Appeal held, we say wasn't competent to so hold, that the grant of bail was a nullity, and it was of no effect. That's what they said. There was nothing to obey.
Okay, so I think I now understand. You're drawing the distinction with Smith and Destello, not in relation to the first question.
No.
Whereas it seems to me you're perfectly happy with it and indeed endorse it as a principle.
Yes.
But in relation to the second question, where you say that there may be differences.
Absolutely. Well, there plenty are.
I've now understood what you're saying. Thank you very much.
And the first and the argument on the first ground is much stronger, we would respectfully submit. Because in Mosul, at least in principle, I accept in the context of detention, you can't take a chance and think, no, the bail's erroneous. In the Mosul case, the board could ignore it, the minister's direction. That's what Lord Phillips said. You on your legal advice, you ignored the direction. As it happens, you're right to do so. No problem. If it had been a court that was directing the board, the regulator, to act in a specific way, it could not have disobeyed it. That's the difference. At time one, let alone when it's set aside. My lord, the divorce cases, because Secretary of State placed reliance on that, and I think I've got about 8 minutes. We don't, with great respect, I think this is possibly the only place where we differ with Mr. Weston, we do not accept a natural justice exception to the Kremer rule. That is not in our submission what is going on in the divorce cases. They can be addressed by reference to 4 points. Firstly, they're an application rather than a breach of the rule in Kremer, because the wronged party isn't aware of the order. When she becomes aware, she takes steps to have it set aside. And I've given you the references there. Secondly, all the cases say, particularly Lord Justice Andrew Leggett in the Manchanda case and Mr. Justice Wall in Dennis, they say that the grant of a decree absolute is an administrative rather than a judicial act. And that has consequences for retroactive invalidity and so on. Thirdly, they rest on this distinction, Lord Leggett again, not Lord Justice, Lord Leggett, sorry. They rest on a voidable distinction that my Lord was making, which, and this is Sir James Mumby, short of the Supreme Court, is embedded in this area of the law, behind which lurk terminological, conceptual problems of excruciating complexity. And he was there borrowing from De Smith, so that most judges would associate themselves with the fact that there's no clear or logical principle. So it's a bit of a mess because of this distinction. And if you want to see an example of that, I've sought to give you one over the page at 8, the reference is at 8b Roman 4, where again Lord Justice Andrew Leggett seeks to draw the threads together of 16 cases. And in the reference I've given you, he says that there are some cases where even though there's a failure to observe a condition for the grant of the decree, that's not a voiding case. It's a voidable case because there was jurisdiction to entertain. It's a bit of a gloss on the reasoning there, but you may find it of interest. Going back to my paragraph 6, the final point that we make is that these cases don't concern disobedience. They concern reliance. And we say the unraveling following a finding that a decree absolute was void and no effect is regrettable, is contrary to certainty, but it doesn't undermine the authority of the court. And what I'm seeking to persuade you is that the rule in Kremer is about it's about a lot of things, but fundamentally it's about the authority of the court. And what does that mean? It means you obey. And I will skip over McC. We just say, I'll do it as quickly as I can. I've got 4 minutes. McC is a special context where the common law and Parliament created a balance between judicial immunity for tortious conduct and false imprisonment. False imprisonment being a constitutional protection of a fundamental right. And then we've given you other examples of situations where an order will be a nullity for some purposes, but have legal effects for others. And we look at ouster clauses at 7D and say that here the rule of law points in the opposite direction. It's absolutely orthodox to say that an unlawful act may be held to have no legal effect for some, no doubt most purposes, but retain legal effect for some, for others. And then we say, just to close, in any event, it is, my lord, sorry.
Just so I'm absolutely clear, had there been judicial review of the first tier tribunal's decision in this case?
No.
No, had there been?
Oh, sorry.
And the order of that court was to quash.
Yes.
As I understand it, you're saying that might not have had the same effect as if there had been a judicial review of a non-court order.
That's exactly the point.
That's the point you're making.
That's exactly the point. And the references are, we've given the examples of where there isn't the retrospective invalidation when there is a proper challenge brought. 2D, if you look at 2D of our notes, those are examples where the original unlawful court warrant continues to produce legal effect. Paragraph 8, just to close. Here, the bail order was not obviously or grossly in error or irregular on its face. That wasn't the Secretary of State's view, that's her case, submission A. In her bail objection, we've given you the reference, she said contingently, if bail's granted, you report to the offender manager. She said that, giving you the reference. She conceded at the hearing that reporting to the Home Office was not necessary because you had tagging and there was a requirement to report to the offender manager. The bail conditions do stipulate a time and place for surrender. They don't do it explicitly, but they do it by incorporation because they incorporate the license, which provided for a time and a place. Please see the reference. In correspondence, the Secretary of State accepted that the FTT had granted bail and asserted that you were only required to attend the offender manager. That's when your bail terminated. How on earth is this an order that's obviously wrong or invalid on its face? With respect, it's an impossible submission. Nor was it in excessive jurisdiction. Lady Rose, for reasons which we address here, a reconnaissance was given, if you need to do that, to even entertain. We say to entertain the question, you just have to be detained. Yes, you've got to enter into reconnaissance to have it, but that's not, doesn't go to constitutive jurisdiction, the jurisdiction to entertain. Time and place for surrender was indirectly stipulated, the point I made earlier. And the point of construction at B Roman 3, we submit in the legislation, Parliament is to be taken as permitting reporting to an offender manager rather than an immigration officer with liaison, given you are going to have many people who are both on license and subject to immigration bail. That's what happened here. The moment he was eligible for license, he was detained under Immigration Act powers, and therefore he sought bail. Such direction was directed here, is directed on a pro forma basis. See the inelegant block capitals I've got. You've got the blocks in the form, and we say on any view there is jurisdiction to entertain, and if there's doubt, the question of jurisdiction should be interpreted in a way that least restricts liberty. Then finally we say the learned friend submission is a recipe for chaos. It produces situations which are most invidious for individuals. The appellant resisted the imposition of reporting condition. Mr. Weston has addressed you on that. That was imposed. And it was imposed on pain of a fine or up to 6 months imprisonment. Same point about the unpaid work. He was working for Age Concern in Worthing. It's irrelevant that the upper tribunal thought that was for the Secretary of State. If you look at paragraph 65, 64 of its judgment, it's the same Kremer point applies. There was a court order saying effectively you can work unpaid. And I'll just close by inviting you to paragraph 91 of the Secretary of State's case at EF 190, where the Secretary of State claims a power to disregard bail to the extent of detaining on executive warrant somebody who has received a court order in favor of their liberty. That's what the Court of Appeal has permitted here by its reasoning, treating an order of court as an executive act, declaring it procedurally wrongly in defiance of the rule in Kremer as a nullity, saying there was nothing to obey. It's an Alsatia that's created, we respectfully submit, which is completely inapposite anywhere in the rule of law, any system governed by the rule of law, a fortiori here. Those are my submissions. My lords, if I've been impertinent at all, please forgive me. I was worried, very much worried about the time.
Thank you very much, Mr. Hussain. We'll adjourn now and resume at 2 o'clock.
Thank you very much.